Okay, welcome everyone to our new episode in our webinar series, The Transformative Power of Law to Address Environmental Challenges. That's a webinar series where we discuss timely developments in environmental law and governance. My name is Christina Voigt, and I am the chair of the IUCN World Commission on Environmental Law, which organizes this webinar series, and I'm a professor of law at the University of Oslo. Today's webinar focuses on recent developments in carbon markets under Article 6, Paragraph 4 of the Paris Agreement. Under Article 6 of the Paris Agreement, parties can pursue voluntary cooperative approaches to reach or even increase their climate targets. Article 6, Paragraph 2 foresees bilateral cooperation between parties, and Article 6, Paragraph 4, what we will focus on today, Article 6, Paragraph 4 established a new UN carbon crediting mechanism called the Paris Agreement Crediting Mechanism, or PACM, for want of a very easy acronym. Very simplistically, the Article 6.4 mechanism, or PACM, allows a participant, which can be a state or company, in one country to reduce emissions, have the emission reductions credited, and to transfer them or sell them to another participant or buyer in another country. The parties to the Paris Agreement agreed in Glasgow in 2021 on the rules, modalities, and procedures for the Article 6.4 mechanism in Decision 3 CMA 3. However, the further development of more concrete guidance and standards is left to the supervisory body, the SBM, for the Article 6.4 mechanism. The supervisory body is the governing body for the mechanism. And this body has been very active. Only this year, in 2024, several important steps were taken in the governance of the Article 6.4 mechanism. In May 2024, the SBM adopted an appeals and grievance procedure, which allows people affected by decisions of the supervisory body to appeal the decision or to file for a grievance. This is based on lessons learned from the Clean Development Mechanism under the Kyoto Protocol, which did not have any appeal mechanism against the decisions by the executive body. And at the latest meeting of the supervisory body, which took place in October this year in Baku, 3 more important steps were taken in order to kick the Paris Agreement crediting mechanism into motion. One was the adoption of the Sustainable Development Tool, which mandates human rights and environmental safeguards. And the other one was the adoption of 2 standards. One standard on methodology requirements and one standard on activities involving removals. These standards were forwarded to the CMA with a request to endorse them by CMA 6, which will take place in Baku from next week onward. This is a different approach to normal procedures, and I'm sure we will hear much more about this during our webinar today. We are therefore incredibly privileged to have with us here today Felipe Ferreira. He is a member of the supervisory body of the Article 6.4 mechanism, and he negotiated throughout the course of this year these 4 and many more important steps which the the supervisory body has taken. Felipe was involved in the negotiations of the Paris Agreement as lead mitigation negotiator for Brazil, and he also was involved in the negotiations and adoption of the rules, modalities, and procedures for Article 6.4 in Glasgow in 2021. He is a career diplomat at the Ministry of Foreign Relations in Brazil, and he is currently Deputy Consul of Brazil's consulate in Cordoba in Argentina. And I think also this is where you're calling from today, Felipe. But, and this is important to highlight, but he serves at the supervisory body in his personal expert capacity. We would like to welcome you, Felipe. And before you get the floor, I just want to sketch out how this webinar will be structured. Felipe will be talking for about 20-25 minutes, and then we will go over to a Q&A session moderated by Dr. Fabiano Andrade Correa. He is the chair of the IUCN WCEL's Climate Law Specialist Group, and he is also here with us on the screen. Before we start, please let me inform you that the webinar is being recorded and it will be published on the IUCN WCEL website in due course. And without much further ado, Felipe, you have the floor.
Thank you. Thank you very much, Professor Voigt, and thanks the WCEL and IUCN for this very generous invitation and opportunity to address the group today. I have prepared a small presentation. It's more like bullet points, but just to help me follow up on my train of thought here. I have to say though, most of my points were already raised and introduced in your introduction. But that's gonna be just shows how updated you are on this topic. So once again, thank you for the invitation. And just to reinforce the disclaimer already put forward by Professor Voigt, the views here are presented in my personal capacity and do not necessarily represent the views of the Ministry of Foreign Affairs, of the Brazilian government, or any other organization, including the supervisory body of the mechanism. I assume all of you are somehow familiar with the mechanism already, but just to give some background information, the PACMAN, it's a very, very hard acronym to pronounce, but the PACMAN builds upon the experience of the clean development mechanism established under the Kyoto Protocol. This new mechanism is established under the Paris Agreement, Article 6, Paragraph 4, further elaborated through Decision 3/CMA3, the rules, modalities, and procedures, or just RMPs, as we call it in the body. These were developed during the Glasgow conference. The mechanism operates under the authority and guidance of the parties of the agreement through the CMA, which establish the supervisory body to oversee the operation. We are 12 members and 12 alternates in the supervisory body, following the usual geographical balance of the United Nations system. What the supervisory body does is to oversee the development and implementation of activities under the mechanism. The goal here is to facilitate the collaboration among parties, among private entities, to invest in greenhouse gas emission reduction activities. And it does so by generating verified emission reductions, by generating units. These units, these emission reductions can have two different status. Emission reductions that are authorized to be transferred internationally under Article 6.2 of the agreement, and therefore they generate a corresponding adjustment in the national accounting of parties and DCs. We call these ITMOs in the negotiations, International Transfer Mitigation Outcomes. But the mechanism also issues verified emission reductions that contribute to mitigation efforts in the host country and do not generate a corresponding adjustment. And these are used towards climate finance or other voluntary purposes. And we call these the MCUs, the mitigation contribution units. But this is just a small detail. I think the main idea of the mechanism is that the mechanism serves as an international public certification system for carbon credits with the UN stamp, with the legitimacy of being developed through the UN multilateral system. And therefore, it serves as a public and open tool to finance mitigation activities and to also facilitate emission trading. And by doing so, it acts as a channel for the private sector, for public agents, and also for other non-party stakeholders to be able to engage in the mitigation efforts of the Paris Agreement in a way that's fully measured, reported, and verified. Is the presentation going? Yes. And 2024 has been a busy year. After very long and protracted negotiations for the regulation of the mechanism since 2016, I believe that 2024 will probably be remembered as a watershed moment that allowed for full operationalization of the mechanism. In particular, there are 4 recent developments or recent products that were adopted by the supervisory body that puts us on track for this. As Professor Voigt already mentioned, we have adopted 2 standards, with standards for methodologies and the standards for activities involving removals. We also have adopted 2 for environmental and social safeguards, the Sustainable Development Tool, and we also have adopted a procedure for appeals and grievance. The standards, the first 2 will be of particular interest on a more technical side for carbon accounting and carbon and activity development, while I believe the latter 2 may be a little bit more interesting, have some interesting legal implications that the WCEL should probably have a closer look in the implementation of the mechanism. Regarding the standard of methodologies, what I think is important to take note here is that this is a standard that applies to everything and anything being developed under the mechanisms. Those are requirements that are going to apply to all activities under the Paris Agreement credits and mechanisms. It has, compared to previous experience under the Kyoto Protocol, and also compared to a lot of the so-called voluntary markets, I would say it has requirements that are considerably more stringent. In particular, the baseline for crediting from the outset has to be below the business as usual projections. And furthermore, this baseline is also subject to downward adjustments over time, which significantly reduces the supply of units being offered. There are 3 basic approaches for developing a baseline. One is comparison with the best available technologies. The other one is a comparison with ambitious benchmarks or averages of comparable activities, and also a historical baseline based on on past data. In the downward adjustment, they apply to all of these approaches. Another characteristic that I would like to highlight of this standard is the concept of additionality. Now, all of you that are familiar with the CDM know that additionality is a key concept into credit. Basically, the idea is that you're only issuing credits for activities that would not happen in the absence of the incentives of the mechanism. So it's a counterfactual to some extent, but it's not just a counterfactual, and it has some cumulative requirements that go beyond previous experience. These are 4 cumulative requirements to demonstrate additionality. The what's called benefit considerations, which is basically the analysis of how the mechanism can benefit the activity. Avoidance of lock-in, which is also a new requirement. The idea here is that by incentivizing certain activities through Article 6.4, we are not locking in certain the emission levels. A third, and maybe the most I'm not sure if we could call it the most important, but the most it's the default approach to characterize additionality, which is financial additionality, meaning a financial demonstration that the monetary gains of the mechanism are necessary for the activity to exist. This is the default approach. It has some alternatives, such as performance-based approaches or an analysis of barriers, but most activities will demonstrate additionality through financial analysis. And a fourth one is regulatory analysis. The idea here being that the activities must go beyond the host country's existing law and regulations. And this is what I think it's interesting to highlight here is that the requirement for regulatory additionality under 6.4 has a much more stringent and restricted interpretation as there was under the clean development mechanism. And under the clean development mechanism, and this is a recurrent theme in the carbon crediting discussions, you had some leeway to demonstrate whether or not that particular regulation was being implemented. And a lot of members of the SBM feel very strongly about that, in the sense that this could create perverse incentives, and therefore Article 6.4 has a more stringent approach to regulatory additionality. But this approach, nevertheless, has a caveat, which is at the same time to allow Article 6.4 to be used as a legal and policy instrument for host countries in developing their mitigation activities. The second standard that was adopted in the last SBM meeting is the standard for removals. And removals here is has much broader meaning than what we had under the CDM. Under the CDM, removals was restricted to afforestation and reforestation activities, while the rules, modalities, and procedures of the Article 6.4 adopted in Glasgow have a more technologically neutral approach regarding activities. So removals under 6.4 applies potentially to any activity, be it forests, carbon capture and storage, and also includes emission reduction activities that may have a significant risk of reversals. It's a very engaging topic. It has what I would like to highlight here is that the definition for removals under 6.4 consider only positive net changes in the carbon stock and not the stock itself. So under 6.4, we're not talking about emission avoidance. We are talking about either an emission reduction or a change of the stock between two periods of time, a positive change in the carbon stock. Another significant innovation under 6.4 is that while under CDM we had an approach of temporary credits for removal activities, under 6.4 we have taken an approach based on a risk evaluation and a buffer pool. So the risk evaluation is, the details of the risk evaluation are still going to be discussed starting next year. But the idea is that based on the risk evaluation, one determines how many units have to be deposited in the buffer pool. And these units can be canceled should there be a reversal. In case of reversal, the activity participant is entirely liable to replenish the buffer. And it may do so by transferring units from other accounts under its name. It may do so by transferring other units from the same activity. It may do so by acquiring units in the market. But we are also looking into other approaches to try to create more permanent solutions and to avoid and to strengthen the resilience of the buffer. One key concept of the standard of removals that it's going to be very interesting to follow during implementation is the idea of avoidable versus unavoidable reversals. And this will probably lead to interesting legal discussions. Basically, by definition, under the standard, avoidable reversals are all reversals under the control of the activity participant, while unavoidable would be anything outside its control. Including, for example, the same effects of of climate change. So the more climate change we have, the greater the risk for reversals. Those reversals are considered unavoidable to some extent, and this has to be reflected in the risk evaluation. I think the nitty-gritty and fine line about when a reversal will be considered avoidable and when a reversal will be considered unavoidable is something that climate lawyers should follow very, very carefully in the future. The fourth development this year is our Sustainable Development Tool, which is the system for environmental and social safeguards. The clean development mechanism had a sustainable development tool, but it was not mandatory. It was optional. And the SD tool under the 6.4 has gone much further. It's not just a tool to assist in the activity design, but in practice, it creates what can be described as a safeguard verification system, which is a mandatory requirement before the issuance of any emission reduction units by that activities. So activity participants are required to identify, evaluate, avoid, minimize, and mitigate potential risks associated with their activities. Throughout the implementation of the activities, they are also required to monitor these risks against specific indicators that have been developed based on social and environmental safeguards, but also based on the Sustainable Development Goals. And I think that's a very remarkable thing, that actually the Paris Agreement crediting mechanism is providing a service that not even our colleagues in the SDG negotiations were able to develop, which is a monitoring and verification system for SDG indicators that apply at the activity level, that apply to private entities, for example. The process of implementing the tool, it also includes stakeholder consultations in several moments of the activity cycle, but also the tool and these indicators, they have to be followed not only by the activity participant, but also by the designated operational entities, which are the independent private entities responsible for making the validation and verification of activities before we can issue any credits. Fourth, we have also adopted, that was not in this last meeting, it was a previous meeting, beginning of the year, the appeals and grievance procedures. And here, once again, it's innovation. That's not something that it's the first ever under the UNFCCC system. It might be the first ever under the UN system, but basically, it's a procedure that establishes the administrative steps to appeal against a decision of the supervisory body, or procedures to submit a grievance, which have to be addressed by the activity participants and host country authorities during the implementation of the activities. An appeal against the supervisory body decisions is remarkable in itself. It's something that didn't exist before, and it created some very traumatizing cases under the clean development mechanism, where even though there was goodwill of the executive board to do something to address concerns by stakeholders, they actually had their hands tied, and any decision by the executive board was final. So this is not the case under the Paris Agreement crediting mechanism. Stakeholders, activity participants, and nationally designated authorities can appeal against SDM decisions, which may lead to the suspension of said decision until a panel of experts rules on the merit of the appeal. The grievance procedure is directed not necessarily towards activity participants, but by those who may be affected by 6.4 activities. So the idea is to address potential adverse effects that are suffered or may be suffered by individuals, communities, or local businesses that are in the area of influence of a particular activity. The grievance, similarly, in case a grievance is put forward, a technical panel will assess the case and make recommendations to the activity participants, to the national designated authorities, and or to the supervisory body on possible corrective actions to address the issue. This explicitly does not include monetary reparations. This is not a judiciary body. It's an administrative legal pathway, but it may lead, for example, to the suspension of units and the issuance of units of a particular activity. And I think what's interesting to note here is that even though it's not a judicial procedure, it creates a pathway for stakeholders that did not exist before, and therefore provides them with some degree of oversight over activities being conducted under the mechanism. Well, so this has been our year. We have the next couple of weeks the CMA in Baku going on. The supervisory body has recommended the CMA to endorse the approach and to provide any further guidance on this matter. It's important to note that this is a slightly different procedural approach to last year. In Dubai, the SBM recommendations were not adopted by the CMA. There was no decision. It was Rule 16. And it was Rule 16 on other topic. There was no decision, and they gave us some homework back to conduct a public consultation process. And this year we have adopted an approach we have taken an approach to adopt the requirements for methodologies and removals as a standard, which is a living document that can be updated. And we have asked the CMA to endorse this approach. This will hopefully allow for smoother negotiations. There are higher level issues and more complicated political issues being negotiated under the scope than 6.4, including on the guidance on 6.2. But 6.4 can start moving forward independent of this guidance on 6.2, although both they're both interrelated. Starting next year, the SBM will be in a position to adopt specific methodologies. There are already some in the pipeline of our methodological experts panel. And these include the transition of some CDM methodologies regarding renewable energy. It also opens the path to registration of activities and in the near future also to start issuing units under the 6.4 registry. And that's why I believe that 2024 will be remembered as a watershed moment in the operationalization of Article 6.4, and hopefully in the very, very near future, we will be having activity cycle up and running throughout host countries everywhere in the world. I think that pretty much sums up what I had to say, and I also am conscious of the time. I'd like to thank you very much for your attention, and we'll be delighted to answer your questions now. Thank you very much.
Thank you very much, Felipe, and good afternoon or good evening, everyone. My name is, as Christina mentioned at the beginning, is Fabiano de Andrade Correa. I am the co-chair of the Climate Change Law Specialist Group of the IUCN World Commission on Environmental Law. And now I'll have the pleasure of moderating the Q&A session that we have following Felipe's presentation. We have about 25 minutes for questions and answers, and we would emphasize that we would love this to be a very interactive discussion with those watching online. So please don't be shy, and do post your questions in the Q&A section of the Zoom. And maybe just to start, I think, Felipe, this was such a privilege for us to listen to you from an insider perspective on all these issues. As we know, carbon markets have been an issue of such a strong interest, and since the adoption of the Paris Agreement, really one of the topics that I think have been most thoroughly negotiated and still are, as you have mentioned. On the one hand, stakeholders such as the World Bank have been really emphasizing carbon markets as one of the key solutions to bring additional climate finance debt-free to countries. And on the other side, of course, we still hear many challenging situations, especially with regards to voluntary carbon market standards, and really the need to pay a lot of attention to integrity issues of carbon markets, both on supply side but also on demand side. So I think all these developments are very, very timely and fortunate, and really point to the direction of creating the tools to ensure this high integrity. So this is all very interesting. We have already 2 questions in the chat, so I'll start with those and we take it from there. So Felipe, two questions for you. The first is, based on the definitions and requirements under these standards that you mentioned that were just published, is there a move to focus more on technology-based removals and away from nature-based removals? So this is the first point. And the second point is, could you kindly discuss which nature-based technologies might be the first to be in the pipeline? So over to you for this first set of questions, and then we collect some more. Thank you.
Thank you, Fabiano, and thank you for the questions. I think they are both interrelated. I'm gonna try. I'm gonna make an attempt to answer them in conjunction. What I would say is that the SPM and the rules that guide the supervisory body, the rules adopted in Glasgow, have a very, very clear what we call a technologically neutral mandate. We are trying to develop rules that would apply to any activity as long as they fulfill the long list of requirements established in paragraph 31 of the rules, modalities, and procedures. So if there is a move to focus on tech-based removals and away from nature-based removals, I would say no. There is no move towards that. But it's important to have in mind, and I think this will become more clear in the near future when we start to develop the risk assessment tool and also adopt specific methodologies, that there are different challenges that are very context specific to each type of removal. So tech-based removals, basically CCS, it has, what we're talking about is basically digging a very, very big hole and pumping greenhouse gases in it and putting a lid on. This has a specific type of risk, geological risk, for example, which poses a different kind of risk, which hopefully can be quantified, than a nature-based solution where you have laws and regulations by the country, but you're basically talking about the management of private property. And these nature-based solutions are, I would argue, are more subject to the effects of climate change itself. So these things, there is no preference, there's no move from the SBM. Otherwise, we would be taking an approach based on what kind of activity should be eligible or not, and we are not doing negative lists unless, of course, the CMA decides otherwise. So so to summarize, I think the approach, it tries to be neutral, but we will have probably in the implementation differences arising from the different types of risks, and also the different implications that those risks have for activity participants and also host country roles in this. I mean, one of the discussions that we didn't have yet, and it's going to be very tough, for example, is the monitoring of removals after the crediting period. Activity participants in the private sector, they claim, which is somewhat reasonable, that they cannot monitor the thing for 100 years, that the states should take over that role. At the same time, one cannot expect states to take over that role throughout a century and not, if they are not part of the activity in the first place. So these solutions, we will have to come up with some interesting technical solutions to deal with different types of risks and also different appetites for risk. I think it's a very different thing to monitor forests and to monitor a hole in the ground. The second question, which nature-based methodology might be the first to be in the pipeline? I would bet given that we already have a mandate to review all CDM methodologies, I would bet that afforestation and reforestation methodologies are strong candidates to be the first in the pipeline to be evaluated with regards to nature-based methodologies. But I wouldn't rule out if activity proponents or even countries put forward REDD+ methodologies, which have very, very long and strong history under the convention, and which have been incorporated in the Paris Agreement through Article 5.2. In this regard, just like to a brief note, the standard is technological neutral, but it has a specific reference to REDD+ activities, which provides some clarification with regards to the relationship between 6.4 and 5.2. And basically what it says is that any REDD+ methodology that may be presented to the supervisory body, they will have to demonstrate that those activities they are integrated into all the national level elements of REDD+ countries, and that was very important. That was a very important point to avoid a scenario where private entities would try to do forest-based activities through 6.4 and circumventing the national elements of 5.2, but it also allows the same private entities a pathway to do REDD+ the right way without circumventing more than 10 years of decisions and regulations on this issue. Thank you.
Thank you very much, Felipe. This clarification on REDD+ was, I think, also very, very relevant. So thank you for mentioning that. A next question is if you can discuss distinctions between carbon credits and offsets in the context of 6.4. And then perhaps there's a question about main challenges currently facing the 6.4 mechanism. And perhaps we could address this towards the end. I think it would be interesting to combine that question with your views and expectations towards COP29. But perhaps another technical question comes in the meantime. So perhaps you can start with this distinction question, and we can then go into those challenges and expectations.
Well, it's tough to talk about the distinctions when you look into the carbon community. People use these terms somewhat interchangeably sometimes, and sometimes they are very different. What I think is useful, the distinction that's useful here is that under 6.4 is the distinction between ITMOs and MCUs. And the point here, there's no hierarchy between one or the other in terms of environmental integrity. The rules are exactly the same for both of them, for both authorized emission reductions and for mitigation contribution units. So the rules are the same. They are fundamentally the same when it comes to environmental integrity. The main difference is the impact that these units may have on NDC national accounting, and the impact that these units may or may not have in the capacity of host countries to achieve their NDCs. So if you consider an offset something more akin to ITMOs, I think it's important that falls a little bit more under the 6.2 rules and rather than 6.4. But I think what it creates, it's a distinction or a conceptual decision, the distinction between ITMOs and MCUs. It creates a conceptual distinction between who is actually being financed here. Because if you issue a carbon credit and that carbon credit is used towards someone else NDC accounting or towards someone else's mitigation commitments, basically who is being financed here is not the activity participant. The activity participant gets money, but who is being financed is actually the purchasing party, because the purchasing party is fulfilling its legal requirement at a lower cost. While the MCU or carbon credits in general, because they do not generate a corresponding adjustment, the financing is indeed towards the host country and the activity participant. And I think one of one of the main challenges that Article 6.4 faces and will face in the future is that the carbon community is still too much focused on the carbon trading aspect of things, on financing whoever purchases the carbon credit, and not as much into the carbon finance aspect of it. And one of the challenges that I think we're going to have, and it's not a discussion under the SPM at this moment, but it will be a discussion for each host country, is how to use the units being developed by the Article 6.0 mechanism to mobilize finance. So we could, this is a fascinating topic, and it's a fairly new topic. I mean, the decision, I don't remember the number of the decision, but it was the decision in Sharm el-Sheikh when they had this conceptual division between authorized and MCUs. The decision is names specifically the use of MCUs for performance-based finance, for results-based payments, for other sorts of climate finance. So one could envision, for instance, a financial institution, a multilateral or national one, creating different levels of interest rates, right? Depending on how many units how many MCUs one issues and cancels. You could establish MCUs as a requirement for certain activities. One could also establish, instead of traditional finance modalities of climate finance, where the donor gives the money and controls how that money is used, you could have decentralized modalities for climate finance with reverse auctions. Basically, instead of using the money to pay for consultants, use the money to buy MCUs and cancel them. And that's also an interesting way to use 6.4 to mobilize climate finance. There has been some experience with these sort of things under the CDM through voluntary cancellation and reverse auctions. But I think we will soon, hopefully, be in a position to expand that at a much greater scale under Article 6.4. I mean, there are several challenges, but I would be particularly, I would pick that one. That one is my pet peeve and my favorite challenge ahead of us.
Thanks, Felipe. We're going towards the final 5 minutes of the webinar. Perhaps if you'd have some concluding thoughts on how do you see all these issues playing out at COP? Any new issues that might emerge that you expect? What are your general expectations? Is the endorsement gonna go smoothly? And anything else you'd find interesting to share with our audience today, and then we can conclude.
Well, I'm very sorry that we are concluding already. Maybe I have taken too much time in my answers.
No, not at all.
I would ask, I can see there are some questions that have not been answered. If Fabiano could maybe forward them to me, and I would be happy to reply them at a later time.
Perhaps, Felipe, we can.
Yes.
Perhaps we can have a couple of more questions. I hadn't seen that there were actually so many.
Okay.
Okay, let me pick this one. What penalties will be imposed on companies for intentional fraud in regard to the many opportunities which should be sufficient to deter such frauds? Monitoring will not ever be sufficient absent such deterrence. We know that fraud has been rampant in financial markets when there is significant funding at issue. And another one, has there been any discussion of hybrid credits, the value of which combine carbon and climate benefits along with benefits for biodiversity? So if you could perhaps take a couple of minutes to answer those, and then some final thoughts, and the rest we'll make sure to forward to you to be addressed offline.
Well, it's a question by an anonymous attendee. I'm not sure which fraud they are referring to specifically. If we are talking about financial frauds, as in pyramid schemes that used fake carbon standards, or if we are talking about fraud in the implementation of the activity itself. I cannot speak for the first one. But I think that having a multilaterally developed system should offer a more legitimate way to do carbon crediting. And hopefully, on the demand side, companies interested in acquiring such credits, be they FCUs for voluntary purposes, be they ITMOs for regulatory purposes, hopefully they will see that it's much more reliable to do that through 6.4 than through someone advertising their services in LinkedIn or their Instagram account. With regards to potential frauds in the development of the activity itself, we are not a judiciary body, so we can't really impose a penalty. What we can do is to suspend the issuance of any credits from such activities. The grievance procedure allows for that. The appeals procedure also allows for that. And this should be a penalty enough, but I think in some extreme cases, it may even go back to the cancellation of previous units issued, depending on the findings of the grievance panel. I think the supervisory body cannot do that ex officio, applying any penalty, and of course, this is the kind of question that should also be first and foremost put forward to local authorities and judiciary bodies, but the SPM, through the grievance and appeals procedure, will be in a position to avoid the continuation of the activity. Regarding hybrid credits, the value of which combine carbon and climate benefits along with benefits for biodiversity. There is a lot of indicators and elements related to biodiversity in the safeguards information tool. So I would dare to say that a 6.4 unit benefits biodiversity concerns, even if only by proxy. Now, if we are talking about credit that incorporates into its own methodology biodiversity related indicators, no, there is no talk about that. And I'm not entirely sure. I have a lot of friends in the biodiversity community, and I know this is a very hot topic there. But sometimes I think it would be, it's questionable. It's a similar discussion to what we had with non-carbon benefits, rewarding non-carbon benefits under REDD+. In the decision that was adopted in Paris. It's one thing to reward biodiversity through emission reductions, through verified emission reductions. Hopefully, if you're doing it right, it should have biodiversity benefits. It's another thing to create the whole methodological infrastructure that revolves around biodiversity indicators. And that actually creates technical difficulties that may be counterproductive. I think it's more promising to use units from nature-based solutions under 6.4 or results-based payments through 5.2 to generate biodiversity benefits rather than try to create a biodiversity financial asset in itself. Do we have time for a little bit more?
Yeah, I was just told we can take a few more minutes. So I don't know if you're finished with this question, but we have a final one that I'd like to pose to you. Are you finished with that one?
Yeah, I'm finished that one. I finished that. Sorry, I was just looking at the text. I think someone's raising their hand. Apparently, there's a question that we walked over.
Yeah. So the question is, if you could share some further thoughts around the issue of ensuring informed consent of indigenous peoples, as this represents an improvement on the CDM as opposed to the CDM. And the second part of the question is, the uneven geographic distribution of CDM projects was an issue of persistent concern. How do you see the Paris Agreement crediting mechanism evolving to promote geographic distribution, particularly with regards to less developed countries?
Well, let me start with the second one, which I think it's a little bit easier. I think there's some trauma from the CDM with regards of overconcentration of activities in certain countries. That is to some extent to be expected, of course, because you need scale to reduce emissions. And you need a certain scale of economic activity in order to be able to reduce emissions. Nevertheless, under the PACMAN, we have to less developed countries, we have easier requirements, basically. We are in a position to give them a little bit more methodological slack, and also to offer, I think less developed countries will be some of the ones that benefit the most from standardized baselines. We also have adopted this year a standard for programs of activities, which allow for smaller countries to pull together several activities and go through the activity cycle and verification procedures together instead of, and that reduces transactional costs. So I think we are in a better position to have better geographical distribution. And also, one thing that's sometimes is forgotten, there's nothing preventing developed countries to act as host countries of the mechanism. So you could also have developed countries engaging with the Paris Agreement credit mechanism as host countries, which is something that people don't have in mind a lot of times when they're developing the rules that may someday apply to themselves. Regarding informed consent, the consent of indigenous peoples. So I think that goes, there are 2 points in time where this applies, or 2 products of the SPM where this clearly applies. The activity cycle per se, which is the standard that was adopted last year, if I'm not mistaken. The activity cycle includes necessarily stakeholder consultation. Any stakeholder that may be directly affected by the activity in their geographical area has to be part of the activity development. With regards in particular to indigenous peoples, we have several references to previous informed consent of indigenous peoples, both in the Sustainable Development 2 and the appeals and grievance procedures. And these are also, so if we're talking about an activity that may affect indigenous communities or traditional communities and indigenous peoples, we are basically through the Sustainable Development 2, prior informed consent is a mandatory requirement, and it has to be done when available. It has to be done using local protocols. So it's the communities and indigenous peoples themselves who decides how these consultations are gonna take place. So I think that's also a very progressive aspect of Article 6.4 that you definitely don't have in the so-called voluntary carbon markets that portray themselves as alternatives. Thank you.
Thank you very much, Felipe, also for generously staying a little bit over time. But I think now we're almost 10 minutes beyond our planned schedule. So I'll thank you very much and thank everyone indeed online who has been with us for this hour. If there's any question that hasn't been addressed, we'll do our best to address them offline. But for now, I'll pass the floor back to Christina for some closing remarks. Thank you very much.
Yes, thank you so much, Fabiano. And Felipe, before I thank you, I just wanted to chip in with a small reflection or just a comment building on what you said in your second last comment on geographical distribution. I think by talking about the 6.4 mechanism, we still have to move out of the Kyoto CDM world into something rather different. And you said there could be a possibility where developed country parties are host countries. And then, of course, the other way around would be then also true that developing countries would be those that actually might buy credits, and in a world where we all move towards net zero emissions, that probably may be a reality sooner than later. But it struck me by listening to you and also following the deliberations of the supervisory body that there's still this perception that it would be developing countries that are the host countries and developed countries would purchase. But I think we might see much more differentiation and different ways of transactions than what we're used to under the Kyoto world. But that just to underline something that you said just a couple of minutes ago. In any case, we would very, very much like to thank you for your time here with us today, for sharing your insights from the inside in a way, but also I think we're very, very privileged of having received that comprehensive overview from you over a rather complicated and complex topic. I think it was very helpful to get everybody on board on what we're talking about, but also you guiding us through the latest developments. And I personally appreciate it very much that you highlighted where there is a room for lawyers to have a look at and to work with, because we have a large community here within the World Commission on Environmental Law, of course, of lawyers worldwide that are interested in carving out the legal aspects of this very important development. And I feel there will be many questions that will occupy us for many years to come. So thank you so much for your time and for explaining this all to you. Thank you to us. Thank you as well, Fabiano, for the moderation. Thanks to Roberto Cole, who is in the back of all this, for setting up this webinar and for maneuvering us through. So thanks, Roberto. He is the executive officer of the World Commission on Environmental Law. And before I close, I just wanted to highlight that we will have another webinar before the end of this year in early mid-December, where we will be focusing on the ICJ advisory opinion process on the obligations of states in respect of climate change. The IUCN is participating in these proceedings. We will be intervening on the 13th of December. We will be the last, the 100th intervention that the court will hear before the judges celebrate Christmas, I hope. But before that, we will have a webinar that discusses the oral proceedings, which by then will be over, and we will provide information about when this is going to happen. So please stay tuned for further announcements and information, which we'll make available on the WCL website and on LinkedIn. But for now, again, thank you so much, Felipe, and thanks to everyone who stayed with us here today, and hope to see you soon again. Thank you.
Thank you.